Hi, my name's Stuart Clubb. I'm a partner and joint head of the commercial litigation team here at Shoosmiths, and I'm talking to you from our Edinburgh office this afternoon.
Amazing. What first inspired you to pursue a career in law, and why did you choose Aberdeen for your studies?
Okay, career in law. I remember first considering a career in law when I was having to choose my standard grade subjects at secondary school. That was the first sort of point that in your life where you've got to start thinking about what you might want to do. And I remember going home that night, saying to my parents, I've no idea what to do. I didn't really have any clear career plans at that point. And I remember my parents saying to me, well, you should go for a career that pays well, and the best paid jobs are either a doctor or a lawyer, is what they thought. But they said to me, they said, Stuart, you can't be a doctor because you faint at the sight of blood, so you should be a lawyer then. And they may or may not have also said that it would probably suit me as a job because I was also a fairly argumentative kid. So that was it really. From that point onwards, my sort of future career path was set in my mind. I was going to become a lawyer. So I'm not going to sit here and pretend it was because I wanted to right the wrongs of society or fight injustice from an early age or anything like that. It was purely because my parents wanted me to get a job that paid well, and I was squeamish at the sight of blood. So that ruled being a doctor out. And I think from that point onwards, everything I did was aimed towards achieving that goal of becoming a lawyer and more specifically a litigation lawyer. And the reason why a litigation lawyer was, you might remember the O.J. Simpson murder trial in 1995, and I was just fascinated by this. I used to, persuade my parents to let me stay up late watching this live from LA every night on Sky News, and it was a huge, colourful news story at the time. But for me, it was more than that. It was about the lawyers, Johnny Cochran, Marcia Clark, sort of watching how they operated in court, how they got their arguments across, how they examined and cross-examined witnesses, the different styles, the different approaches, and I knew then, watching that trial religiously every night, that in some way, shape, or form, I wanted to be a court lawyer. So that was how I got into law and why I wanted to pursue a career as a litigator. And in terms of why Aberdeen, well, I got the grades I needed to study law. I got unconditional offers from, but back in 1995, there were only five universities in Scotland that offered LLBs. Um, so I had to decide which university to go for. There are a few reasons I chose Aberdeen. Firstly, it's a fantastic university. Obviously, it's got a great reputation. The law school's got a fantastic reputation, and it's a beautiful campus in Old Aberdeen. I remember going on a visit and sort of falling in love with the Old Aberdeen campus. There was also the fact that I'm from Peterhead, so Aberdeen is only 32 miles away, so I was already familiar with the city. It also meant that I could go back home at the weekend and get my washing done and perhaps have a proper meal. And then the third reason why I chose the University of Aberdeen, and I don't think this factor can be understated, was the law school's admission officer at the time was an individual called David Lessels. And he was so enthusiastic about the university, and he took a real, genuine interest in prospective students such as me. And I'll be forever grateful for the time that David Lessels spent with me on the phone as I sought to weigh up my options. And he persuaded me rightly, as it turned out, that Aberdeen was the right choice.
Mm. And looking back, how did your time at the University of Aberdeen shape your outlook on the legal profession and your approach to problem solving?
It's a really good question. Gosh, it's probably shaped me in lots of ways that I take for granted and probably don't think about on a daily basis. In terms of my outlook on the profession, I mean, as I say, although I always was very set on a career in litigation, as I mentioned, it did open my eyes to different areas and different disciplines of law that I hadn't ever really considered before. And I think that was because of the university's sort of fantastic teaching staff. I mean, I distinctly remember at one point flirting with the idea of a career in criminology purely because the tutor of that course, a chap called Professor Peter Duff, was so engaging. He was so enthusiastic about criminology as a subject, and that was infectious. So it did expose me to other really interesting areas of the law. And in terms of shaping my approach to problem solving, as a law student, you're constantly reading case law and legislation, and as a litigation lawyer, probably more so than any other discipline, you're still doing that. You're still in the case reports and looking at legislation. So those fundamental research skills that I was taught back in 1996 have stayed with me, and I still use them every day in what I do. And similarly, one of the first societies I joined was the Mooting Society for, well, for obvious reasons, wanting to become a litigator. And again, those skills in legal research, developing, presenting persuasive arguments have stood me in very good stead throughout my career.
Yeah, that's great. And are there any particular experiences or moments from your time at the university that you still remember fondly or that helped you shape your career path?
I've probably touched on some of them already. I
Mhm.
mentioned that the teaching staff at the law school that made such a positive impression, an impact on me. I mentioned David Lessels, Peter Duff, there's also Professor Roddy Paisley, and those are just the names that sort of spring to mind. But I suppose what I remember most fondly is just really the whole experience, the friends for life that you meet, the campus life, really fond memories, studying at the Taylor Library, having lunch in the refectory, drink after lectures in the Bobbin, lots of that sort of everyday university life that, I still look back on fondly.
Yeah. And now looking at your career journey, you've built a long and impressive career in commercial litigation and insolvency law. What drew you to those particular areas?
Look, that's very kind. I've already mentioned the O.J. Simpson murder trial, which, as I say, looking back, was a catalyst for my interest in some form of court work or litigation practice. And specifically, in terms of my interest in commercial litigation and insolvency, I've got to put that down to my traineeship with Chalmers in Aberdeen. That was a litigation only traineeship, and but it was doing a mix of different types of litigation. But the areas I always enjoyed the most were commercial disputes and insolvency. I mean, commercial litigation's extremely varied. In any given day, I could be working on a contract dispute between two businesses or a minority shareholder dispute, perhaps a professional negligence claim as well. And I think that the what goes along with that is the types of clients and businesses that you're acting for are extremely varied. I act for clients across a wide range of different sectors, from energy and infrastructure to tech sector clients and everything in between. So I like that variety in that no, two pieces of commercial litigation are the same. In terms of insolvency law, where I've got a particular interest and expertise in insolvency law, that developed because both of the partners that I worked for while training at Leadingham Chalmers did a lot of insolvency work. And in fact, the head of Leadingham Chalmers litigation team at the time, Marisha Lewis, who went on to become Sheriff Principal Lewis, and then she was the president of the Sheriff Appeal Court, was one of if she was one of the first lawyers, if not the first lawyer, to pass the Joint Insolvency Examination Board exams, which allows you to become an insolvency practitioner. Although she didn't become an insolvency practitioner, she did pass the exam. So I was always exposed to insolvency work and insolvency clients, and have always really enjoyed that aspect of the job.
Mhm. And over your years of experience, how have you seen the field of commercial litigation evolve, especially in Scotland?
God, yeah. Looking back, there's been quite a lot of changes. I'll touch on three main changes I think come to mind. I think the first is the increase in the availability of commercial action procedure for commercial and business disputes in the sheriff courts throughout Scotland. Um, Commercial procedure's got a number of advantages over ordinary court procedure. They tend to be resolved more quickly. You've got expert sheriffs who generally have got a background in commercial litigation, and the intention is you've got the same commercial sheriff that case manages the action from start to finish, and that can help actions progress more quickly. You've also got that benefit of the continuity in sheriff. So there's a number of benefits for businesses in using commercial procedure. But when I first started in my career, other than in the Court of Session, there was only one sheriff court, Glasgow, that offered commercial procedure. Now, well, sitting here in 2025, it's still not the case that every sheriff court offers commercial procedure. I think they can be raised in now, I think it's about 15 sheriff courts. So that's a huge change for the practice of commercial litigation in Scotland, and I think a real benefit for the business community as well. Um, the second main change is I'd probably say is the increase in the use of mediation for commercial disputes. When I first started out in my career, mediation as a form of alternative dispute resolution was really in its infancy, I would say. But in the last 20 to 25 years, there's been a real increase in the use of mediation for commercial disputes because businesses and commercial clients have started to see the benefits of mediation. There's no way to sugarcoat it or get around it. Litigation is expensive and increasingly so. So notwithstanding what I just said about the commercial share of court procedures tending to be quicker, it can still be a lengthy court process. So mediation it can be speedier and significantly cheaper than litigation. But I think the other reasons why it's become increasingly popular for business disputes and commercial clients is it's also private and confidential, unlike a court process, where court hearings are in open court. And it's also much more flexible than litigation because the client's in control of the outcome. So court decisions, by their nature, tend to be binary. There's one party wins, one party loses. But mediation's got that built-in flexibility that clients can come to commercial solutions themselves, which just wouldn't be possible in litigation. And that is often really important in allowing businesses to preserve their sort of ongoing commercial relationships, which is often not possible given the adversarial nature of litigation. So I think that's a real change, and it's easy to see why mediation has become increasingly popular as an alternative to litigation. And then finally, I think the third main change is technology. I think between me starting my career uh, as a trainee back in 2001 and 2020, there was very little change in terms of how the courts use technology. Some, but not a great deal. That was sort of supercharged by COVID when that forced the court system to innovate and email documents. Up until COVID, you would still have to be by the photocopier printing out. The trainee would be printing out, hundreds of pages of court documents and productions, having to physically lodge multiple copies of those with the court. COVID sort of allowed digital technology to be used largely for the first time. So documents and productions are now emailed in as PDFs to the court. I mean, even just using email itself to lodge documents was sped up through COVID, and of course using online court hearings, WebEx hearings for not just procedural business but substantive business such as proofs and debates as well. So I think having seen technology not have a huge impact in terms of the court process with COVID, that changed overnight really. So yeah, commercial procedure, mediation, and increased use of technology, I would say.
Yeah, those are some very interesting points on the changes. Now, as a partner and joint head of dispute resolution and litigation at Shoosmiths, what are some of the key leadership lessons you've learned along the way?
Gosh, that's a really good question. I think it starts for me with clear communication. As in a leadership role, you're responsible for setting the strategy and for the team strategy and the team's vision. But it's not about just setting it. I think it's about communicating that strategy and vision to the team so that everyone in the team knows what that is, whether it be legal directors, senior associates, trainees, PAs, admin staff, whatever role they may have, they understand the strategy. They know what we're trying to achieve as a firm and as a team, why it matters, and I think perhaps most importantly, how their role contributes to that bigger picture. And I think, but by having that clear communication and everyone knowing how they're contributing to achieving that strategy, that makes everyone more engaged and more motivated. But I think clear communication for me is also about being transparent about challenges and actively listening to feedback. So it's a two way process, and that means regular check-ins and one-to-ones with those in the team that I line manage. I always remember when I first started off in my career that the partners all had individual offices, and if you wanted to go and speak to a partner, you had to sort of sheepishly, climb the stairs, knock on their door, and wait to be called in. That's a real positive change. That largely doesn't happen anymore. We're all open plan offices. I sit, all the partners sit amongst the teams. So there's very much that open door approach, and I contrast that with me thinking back to when I was a trainee and being nervous about knocking on a partner's door to ask for advice. It's very much being approachable, that is part of that clear communication, and I think that does lead on to the other key lesson, which is that importance of building trust in a team. Create an environment where people feel safe to turn around and ask me questions if it's the trainee's not sure about something, and share ideas, take ownership, and also challenge and test the strategy, because as leaders, we don't always have all the answers. And if any leader says they do, then they're probably lying. So as a leader in the leadership role here, very much value that feedback and contribution from the whole team. And look, while litigation is very rewarding, it can be very demanding and stressful, and from time to time mistakes can happen, as they do in life. So it's important that you've got that trust within a team that if a mistake's been made or something's gone wrong or not went to plan, then people feel safe to come forward and admit that we can sort it, we can learn from it, we can move on. So yeah, clear communication and building trust, I would say, are the two key leadership lessons.
Yeah, that's a really good answer. And earlier you mentioned the impact the O.J. Simpson case had on you. Is there any other case or project that stands out to you as particularly meaningful or challenging, perhaps?
Well, there's definitely not been anything as exciting or glamorous or headline worthy as me watching the O.J. Simpson trial. But there have been a number of cases and that stand out over the last 25 years or so. I mean, I think the cases that stick out in my mind, Daniel, are probably my sort of career first. I mean, people always say you never forget your first experiences, whatever they may be in life, and that's I think certainly true of a litigator. I'll never forget, for example, my first court appearance at Aberdeen Sheriff Court. It was a small claim case. I think the client was pursuing, say, £500, and the defender had made a time to pay application to pay £1 a month. So it was going to take over 40 years to repay this debt. And my instructions were to oppose that application. So, and I remember before I left the office that morning, the partners had all told me that this application was so ridiculous that I was bound to be successful in opposing it. You probably see where this is going. But for whatever reason, this particular sheriff decided that £1 a month was perfectly reasonable and granted the defender's application. And I've got to say that was one of the longest walks back to the office that I've ever had. So that first appearance always sticks in my memory and gave me a stark lesson in the unpredictability of litigation. Um, my first debate, my first proof, my first appearance as a solicitor advocate in the Court of Session, my first case in the European Court of Justice and traveling to Luxembourg, they all stand out as well as being meaningful in their own ways, I think.
Yeah, that's very interesting. And why do you think diversity and representation are so vital for the next generation of legal professionals?
Oh God, I'm really glad you asked this question. This is something that I'm really passionate about. I think diversity and representation within the legal profession is incredibly important. Look, we need to have a profession that represents the society which we live in fundamentally and which represents our clients because our clients want to see themselves reflected in the profession. If they're instructing lawyers, they want to see people like them in the profession. And I think if particular groups in society don't have that opportunity to pursue a career in law or don't see their particular section of society represented in the profession, then they'll think that this isn't a career for them. And I think in that case, the profession's missing out on that talent and the experiences and the perspectives that they would bring to any firm or organization. And I'm going to say I'm really lucky here at Shoosmiths in that diversity, equity, and inclusion (DEI) is absolutely integral to the firm's strategy because what we're trying to build here is that supportive, inclusive, diverse workforce that reflects all talents and backgrounds. And one of our 4 values at Shoosmiths is being ourselves. We want this to be a place where people can be and are encouraged to be their authentic selves. One example of the way in which we do that, we've got a number of inclusion networks here at Shoosmiths, and I sit on the committee for our Proud network, which is our LGBTQ plus network, and that is about raising awareness and visibility of LGBTQ plus issues across the firm, but also building that sort of community. Also a member of the firm's social mobility working group, which is about boosting social mobility, not just within the firm, but across the UK as well, more broadly. And as part of that, I mentored a care experienced young person for 3 years at one of the local schools, and that was incredibly enriching and rewarding. And I think as a out gay man, it was the first of my family to go to university. Both of these roles and initiatives are incredibly important to me on a personal level. So yeah, diversity and representation absolutely important for the profession for so many reasons.
That's a great answer. And of course, many of our listeners are current Aberdeen students or perhaps recent graduates. What advice would you give them as they begin their legal careers?
Well, I mean, I think law is such a diverse and enriching career. I mean, it opens up so many different opportunities that, unless you're like me and you're hell bent on a career in litigation, then what I would say is, take that time to soak in everything it has to offer, find out what really excites you before you commit to a particular career path. And I would say get as much work experience, no, not just work experience, but as much work and life experience as you can, and think about what will set you apart from others. Getting a traineeship with a law firm, if that's the route that you want to go down, is extremely competitive. You need to think about what experience, what skills will make you stand out and set you apart. There are plenty of law firms that offer, summer placement schemes, for example, but you don't need to have that to get a traineeship these days. Think of the skills that you might have gained from other part-time work or from volunteering at a charity, or maybe you're involved in committees in university societies, for example. Think of what you bring beyond simply your grades, I would say. The grades will, get you your application in the door, but it's what you can bring and offer beyond your academic achievements that is going to take you far in the profession. And what I would say is take any opportunity, grab any experience or opportunity that you can. When I was a summer, it was one of the, I think it was between second year and third year at university, and I wrote round a bunch of law firms in Aberdeen asking if they did summer placements, and they all said no. But one firm came back to me, a small high street firm, and they said, we don't offer that, but our receptionist is going on maternity leave. So if you'd like to work on reception for the summer, and I grabbed that opportunity. I think people get caught up, well, maybe I've not been accepted to the summer placement program or anything like things like that. But think about what other opportunities might be, and just grab that experience.
That's some really good advice, and I'm sure the students will benefit from that. Now, if you could go back to your early careers in practice, what would you tell your younger self?
What would I tell my younger self? Okay, yeah, I think I would completely change my approach to getting a traineeship. Um, I mentioned the high street firm that I worked on reception with for one summer, and they invited me back to do the same the following summer. And I got on really well with the handful of partners, because it was a really small firm, and they offered me a traineeship. And it was an old school chamber practice, so they did a bit of everything, court work, which is what I was really interested in, but they also did private client and conveyancing. And the traineeship that I was offered from them would be doing a bit of everything at the same time, and I was quite happy with that as long as I was getting litigation work. But within a few months of me starting, the court partner left, the court assistant left, and then they decided to disband their court department. So I was left contemplating a traineeship with a firm that wasn't going to offer me any litigation work. And I ultimately assigned my traineeship to Leadingham Chalmers, who I completed my traineeship with, as I mentioned earlier. So I think looking back, I certainly didn't give as much thought as I should have to the type and the quality of litigation that would be an offer from that high street firm, or indeed the resources and support that would be available from them, or how a traineeship with a small high street firm would look if I wanted to progress in litigation at a bigger law firm in the future. So I think looking back, I was probably extremely naive. I thought that any traineeship, as long as I was doing litigation, was as good as any other, and I didn't give as much thought to whether I was choosing the right firm for me as I should have. And it all worked out in the end. But and I suppose that is my other lesson, is that if things aren't working out the way you envisaged, or maybe you find yourself on a path which isn't for you, then pause, reassess, take stock, because no matter how bleak the situation might appear to be at first sight, and I thought my situation was bleak, I thought my career in litigation was over before it even really started. Never give up, because there will be an answer and a solution out there for you. And the other thing I would also do is be patient. I finished my diploma on the Friday, and I started my traineeship on the Monday. Most students these days use that summer to go traveling, enrich their experiences before they commit to a career in the law and start their traineeship. So looking back, I should have absolutely have taken the advantage of those summer months rather than go straight into my traineeship.
Yeah, that's very interesting. And would you have any books or resources you would share with students? Maybe something they can benefit from, or perhaps podcasts?
Yeah, I mean, this is a shameless plug for Shoosmiths, but we've got a fantastic emerging talent team that provides lots of information and resources for students looking to progress careers in law. They've got a fantastic Instagram account, Shoosmiths Grads, lots of really good tips there. So yeah, shameless plug, but the emerging talent section of the Shoosmiths website, lots of good resources there.
And that's great. And I'm sure the students will benefit from that. Now, the last question is, what key qualities or skills do you believe make a successful commercial litigator today?
Key qualities or skills. I think it's a combination of two things. I think it's technical excellence and commercial awareness. By technical excellence, what I mean is the sort of research skills that I talked about that I gained while being at the university. Those analytical and communication skills, because you've got to be able to analyze your client's case. You've got to apply the law to the facts, work out how best to present their case in as clear and as persuasive a manner as possible. And that's both in terms of sort of written argument and oral advocacy. But those technical skills don't mean anything if you don't understand your client's business objectives and what they're actually looking to achieve. It's all very well saying, I think we've got a fantastic case here. You've got really good prospects of success. If actually it's going to be uneconomical or uncommercial to pursue or defend that case, or perhaps it doesn't align with another objective of the business. And sometimes, my role was saying, actually, do you really think litigation's for you because you've got this commercial relationship with the other party here? Perhaps mediation, as I mentioned, is the more appropriate strategy. So I think it's understanding the client's commercial objectives at the outset and then aligning the sort of legal or dispute resolution strategy accordingly. So yeah, technical excellence and that commercial awareness, I would say.